good morning, good afternoon, good evening, everyone. It's great to have you all here in this 4IP Council's webinar. And it is called A Better Way to Unlock AI Transparency and Open Source Mandates. My name is Axel Frazzini. I'm the Managing Director of 4IP Council, and I am your host today. So I'm sure that you know that 4IP Council is a not-for-profit organization, and we do research, academic research mostly. And the goal is to focus on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. What we do is research papers, studies, guides, case law summaries. We also publish interactive graphics, like infographics, explanations, especially targeted at SMEs, startups, but not only. IP Stories podcast is a very successful podcast that we are doing for now a few months. And we are having a sustainability special that you can discover on the website. Everything is on the website, so just come on 4ipcouncil.com and visit. You will find a lot of information, such as, for example, the recording of this webinar and all the previous webinars with Q&A that we have recorded over the last few years. So we have a new area which is called the IoT and cellular standards made simple on the website. You can easily navigate and discover all the benefits of standardization and the Internet of Things across different sectors. That's a great way to learn, not only for the students, but for anyone interested in the IoT. So obviously you can follow us on all the social networks and platforms. I have a preference for LinkedIn, so do not hesitate to follow us or add us. And we can exchange. Our handle is 4IP Council on all those platforms. So you will get the latest IP news, resources, interviews, and notifications for the future webinars. But without further delay, it is my pleasure today to introduce our speaker for this webinar, Michele Herman. So Michele Herman is the founder of JusTech Law, a boutique firm specializing in industry standards, open source software, and technology and IP transactions, especially involving emerging technologies. As an attorney with over 30 years of technical, business, and legal experience, Michele has served as both in-house counsel and in private practice. She has counseled both small and large clients, as well as communities and organizations that develop standards, open source software, and other collaboratively developed technical materials. Just a final remark. Please do not hesitate to use the Q&A tool that is at the bottom of your screen. Just click, ask your questions, and as soon as the presentation of Michele is finalized, we'll take live questions. So, Michele, the floor is yours.
Okay, thank you. So thank you for that introduction, and thank you to 4IP Council for sponsoring my research. So this presentation is about a very straightforward solution to a complex series of problems. I like to think about it in the way when you start to read a novel, you kind of don't know where it's going, but at the end, everything is neatly tied up for you. So let's start at the beginning. And we all understand that there are many benefits to AI systems and many risks. So if we look at the benefits, there are many potential benefits, but we're already seeing many of them now. We see improvements to automation. We're seeing better ways to analyze massive amounts of data in complex situations. We're able to do tasks faster and more efficient than we could before. But there's also a host of concerns. Some of them are perceived, some of them are real, some of them are imminent, some of them may be very futuristic, but we're concerned about things like misinformation and deep fakes and bias and theft of IP and replacement of jobs, weaponization. The list goes on and on and on. We're even concerned that AI may become sentient and we'll lose control over what it does. So a lot of times it feels like we're much more focused on the risks and trying to mitigate them than moving full speed ahead to realize all the benefits that we can achieve through AI. So we really want to understand, how, if we're concerned about these risks, we want to understand, how does the AI system work? How does it make decisions? We want to make sure there's accountability for safety and security and other harmful things. So we're putting guardrails in place, and these guardrails are popping up in all kinds of venues all over the world. We're seeing many, many examples of them. They're implemented through laws and regulations, through international alliances. Companies are making pledges to be safe and secure and not do bad things with the AI that they're developing. We're seeing voluntary standards development and consensus-based organizations that are working on these guardrails. There are so many examples, I couldn't possibly list them all, and every day there's more and more throughout the world. So what does that actually mean for us, particularly for a company who's trying to commercialize products and services based on AI or AI systems themselves? How can you possibly navigate this world of what I'll call these global guardrails or rules, and make sure you're conforming and doing all the things that you're supposed to do every place in the world that you operate? It's not an easy task. And it's especially difficult because we're seeing that the technology itself is in advancement, is really outpacing even this really quick growth of all of these rules and guardrails. So let's start with what this actually turns into. So, okay, we have this big patchwork of AI guardrails. How do we govern that on a global basis? Well, I will say right now that we don't really have a great global AI governance mechanism or a program or even a policy. We have a lot of thoughts about it, but we don't have a lot of implementation. So because we don't have this type of global AI governance, we look at the next best thing, which is transparency. Now, transparency means different things to different people. But even when you look at the different meanings of it, you realize that there may be different stakeholders who care about one meaning more than another. So I've given some examples here on this slide. What are we looking for in transparency, and who cares about that transparency? And these are just a few examples. It's not a complete list, and I don't know that there are specific definitions of, agreed upon definitions of transparencies. But at the end of the day, we want transparency because we want to trust the AI system. So many people think the best way to get transparency is through open source. And so I just want to give a few examples here. So here's an example from the Open Source Initiative, who I'm going to talk about a lot today. The acronym for the organization is OSI, so you'll hear me talk about OSI. And they have up there that open source provides the information that you need for auditing and transparency. The Linux Foundation similarly goes through a lot of reasons why open source and open science and open other things are all good for transparency. Oops. Let me see, there we go. So, it's not really surprising that advocacy groups that specifically advocate to promote open source, what organizations like OSI and the Linux Foundation are going to promote open source for transparency, but they are far from alone. So we see this coming up in many other areas, these guardrails that I talked about. So for example, here is a summary from the EU Artificial Intelligence Act, the AI Act, and it basically makes some exceptions from its rules if you are using open source. Similarly, there's some principles from the OECD AI principles where the countries that participated and the companies that were involved all agreed that it was a good idea to use open source for transparency. So, okay, if we continue on this, what makes an AI system even open source? So I have to kind of step back. So most of us are familiar with the term open source software, but an AI system isn't just software. It has a lot of different components, and not all of those components are software. So the list of components I have here on this slide is from a group of researchers, and I'm going to talk about them later. But they came up with 16 of these components that I list here. People could come up with different components of an AI system. It's not important for what I want to talk about here, and that is that all of the components, no matter how you delineate them, they fall into sort of 4 categories of work product. And the categories are data, software, parameters, and documentation. And why do we care about that? We care about that because there's different intellectual property rights that attach to each kind of work product. In other words, these are the intellectual property rights that you would hold within that work product that you could actually license or make available. And so let's take a look at each one of them and understand what rights we're talking about and how they would potentially be made available. And again, I did the best I could in defining, in actually labeling each of these components as one of those 4 categories. There are some where somebody may say, oh, well, that's not data, that's something else, that's documentation. It's not important, no matter what components you come up with and how you categorize them, they will fall into one of these 4 categories. So let's start out with software. So software is protected by copyrights, trade secrets, and patents. That's a pretty easy one. Documents are they might describe things that, you know, like an invention or something that is patentable, but the document itself is only protected by copyrights and trade secrets. Now, data is a little more complicated. Data, of course, can be protected as a trade secret, but not every data element may be copyrightable. So for example, if it's just a simple number or a simple text string, it may not be the individual pieces of data may not be copyrightable. If they're images or photos or articles, something like that, they're probably copyrightable. In the US, databases can be copyrightable. In other words, they're not subject to special database intellectual property rights, but the database could be copyrightable if its sequence, structure, and organization is sufficiently creative to warrant copyright protection. So now we have AI models, which kind of raise some new work product that we haven't thought about really much until AI became a thing that we're looking at and wanting to license. So AI models often are described as having sort of 2 main files. The first one is actually software code, and it's the architecture. I find that confusing because it's actually software code, not a document describing the architecture, it's the code. And then there's this really big list of numbers, which we call the model weights. And the model weights essentially increase or decrease the connections in the architecture. And they are actually machine generated. So as the model itself is training, that list of numbers changes, those model weights change. So as we mentioned before, the big long list of numbers in and of itself is probably not going to be copyrightable. If there was some structure, sequence, organization that was actually creative, it could be copyrightable, but the problem we have here is it's machine generated. So then there's a real issue as to whether anybody owns a copyright into that, even if it was, in fact, sufficiently creative. And I wanted, so you can see all 4 of these categories have trade secrets involved. So, but the problem is if once you publish them, there's no trade secret left. So you wouldn't have anything else to license if, in fact, you know, if there's no other form of IP other than trade secrets and you publish them, then there's nothing else to license. Now, I do want to mention that other countries, I'm a US attorney, so I can talk mostly about US law, but I am aware that other countries do have sui generis rights in databases. They have their own protection to protect the investments made in them. So I understand that Europe has sui generis rights in databases. And so it may be that there is, a better argument in Europe and other places in the world that may actually protect data in the form of a database or even the model weights as they're generated. But I will leave that to my European and other colleagues on the phone on this meeting who may have a better insight into that. I just want to mention it. So the main point, though, is we have to at least take into account all of these different intellectual property rights in the different components and uncertainties as to whether some of them exist or are even licensable or protectable. So coming back to, what might be an open source AI system, let's first talk about why we might even care and what concerns we have about having a definition. So this is from another research paper, and I'm also going to talk about this research shortly as well. But these authors actually give a good summary of what concerns they have regarding why a definition is needed. The first thing that they basically say is that large companies basically lie about whether their AI systems are open source, and this is called open washing. They say if you open wash, it's going to harm research because you're not really open, and therefore researchers can't really look under the cover and they can't really actually study and use your AI system to do actual research. They also say if you lie about it being open source, you really not enabling anybody to actually look under the cover and learn to figure out whether you can trust this AI system or not. That is the transparency argument. They also really have a problem with large corporations who open wash. They basically say those corporations take advantage of open source, they don't give back, and therefore they make it difficult for small entities to innovate. If we have time, we'll talk about that as well, but they assume that existing regulations and future ones are going to include special provisions for open source AI systems. And they don't want those to be subverted by large corporations that open wash. So that's why all of these reasons funnel into why they think there needs to be an open source AI definition. So let's talk about whether there are any definitions. So the open source initiative has come up with a definition, but let's just start. This is very recent, but let's just start with open source software. Okay, so for a long time, OSI has had a definition, the open source definition. I'll refer to it over and over again as the OSD, and it has 10 criteria. And OSI approves software licenses against these 10 criteria. And if they satisfy the 10 criteria, then they approve them as an open source software license. If they don't meet those 10 criteria, then theoretically they are not open source software licenses. Now, OSI has basically said we're the arbiter of what's open source software and what's not. Not everybody buys into that, but many do. So that is one way. So now for the open source AI definition, we have to look at each of the components. So the software, the data, the model weights, the documentation. So on the software, they basically say you have to have it has to be licensed under an OSI approved license, so something that meets that OSD. And I want to talk about just what that means. So the important components, even though there's 10 criteria, the important ones are one, that the software, the source code, that's the human readable form of the software, that has to be publicly available. The license also not only has to be free, but it has to grant unrestricted rights to anyone to use that software any way they want and distribute it for any purpose. And so in a practical, for those people who are not licensing experts in open source or licensing experts, what that boils down to in a practical sense is that these licenses, if you license your software under it, any one of your competitors can take that software for free, modify it any way they want, use it any way they want, even in their own commercial products, and not pay you anything. So, so the other part of this is the data. Now, the data is kind of complicated because there are, there are actually privacy laws that you can't breach or violate. There are, you might be getting data for training under a license agreement, and that license agreement may prohibit you from making the data available or distributing it in any way or using it in many other ways. And so OSI recognized that. And so while they would still like the data to be available or licensed under an OSI, under what they call OSI approved terms, which we don't exactly know what they are, they did make some exceptions, which I refer to as data exceptions. They said, well, if you can't release the data, it can't be public and can't be made available under all of those grants of rights, then at least describe it and tell us where we can get it and tell us how much it costs to license it. And so that's what I call the data exception. I also want to point out, so the model weights, they also say have to be available and licensed under an OSI approved terms. And since we don't really know what those terms are, we just assume it probably means something consistent with the OSD. So let's talk about what licenses might include these kinds of terms that say the component needs to be publicly available, that it must be you must grant a free license to use it and distribute it anyway without any restrictions. So on the data side, there are a number of specialized data licenses and even database licenses. The Linux Foundation includes a number of them. They list them on their website. There's an organization called the Open Data Commons, and they list some licenses for databases. The Creative Commons licenses are very are used all the time. They're very common. And they to the extent that the subject matter is, like the data is copyrightable, like photos or images or articles, things like that, or the database is copyrightable, then those licenses would be very appropriate. I should mention that the Creative Commons licenses are sometimes used for software, although they try to discourage people from doing that because they're not really geared for that. For example, they don't cover source code and they don't cover patents. So not all of the licenses for these organizations would actually meet the OSI approved terms if you're saying it has to comport to the OSD. Because some of their licenses, for example, Creative Commons has licenses that say you can't make modifications. The Linux Foundation has some that have some field of use restrictions and some output restrictions. So not all of their licenses may meet that definition, but many of them would. But it doesn't matter because there's a data exception. And because as long as you comply with the data exception, you do the description and you indicate where the source is for the data and you give all the information that's required, then it doesn't matter whether or not the license you use for data is going to, whether it complies with the OSD or not. For documents, I just want to say that there are specific document licenses. The Linux Foundation has some of those. The Creative Commons, obviously, their licenses can be used for those. The GNU, the Free Software Foundation, has a few licenses for documents. And OSI, a lot of the approved software licenses actually include documentation in them. Okay, so what about other licenses that aren't listed by OSI as being OSD compliant or don't comport or may not comport to the OSD. So I think it's really important in context of AI to talk about the open rail licenses. Open rail is open because you get access to the source code, that human readable form. And they're rail licenses because they include restrictions on to try to discourage conduct like using the AI system for illegal purposes or harmful purposes or discriminatory purposes. Um, they have the Open Rail organization has different licenses for both software and models, and they have a commercial version and a research only version. So the research only version obviously has use restrictions, and so that clearly would not be um, something that would comport to the OSD, as well as all these other use restrictions that say you can't use it in these bad ways. The Big Science Rail is very similar, and it's basically a predecessor to the Open Rail licenses. Now, there's a whole host of other software licenses that were developed for software, not necessarily for AI, and they have similar kinds of frameworks. And so, for example, there's the Fair Code licenses, and these restrict certain commercial uses or make it really difficult to use that software for commercial use. And one of the reasons is developers want to use this because they don't want to give away their software and not have a sustainable business model. There's ethical licenses, and these licenses are often used to try to curb or influence corporations from doing things like bad corporate practices, so child labor, polluting, things like that. There's a host of vanity licenses. Some of these may actually be OSD compliant. Some of them are not. I like to just raise them because they're usually not on the OSI's list of compliant licenses or approved licenses. But I like to talk about them because they're just kind of fun. So there's like the beerware license, and the beerware license says, here's my source code, do what you want with it, but you have to buy me a beer. There's the O'Reilly servlet license that says, oh, here's my source code, but if you use it commercially, please buy all the developers in your company or are working on your project a copy of my book. There are these postcard licenses. The one for like Overbite says, here's my source code, but please send me a picture postcard to my address in Belgium. And then there's just this host of non-reusable licenses. Some of them are actually listed on OSI's site, but not under necessarily the OSI approved list. And these are, it was really popular at one point especially for companies to come out with their own license. And so some of them actually may be compliant, but nobody else could use the license because it actually is just for that company or just that author of the software. So, what if we actually just like wanted a deeper understanding of what openness is, and not just limit it to this open source AI definition or any open source AI definition? So there are a couple of groups of researchers who have formulated other ways to look at openness. The first one I want to talk about is the model openness framework, and that's the group I talked about earlier where I listed all the different components of the AI system. And the second approach I want to talk about is I refer to it as the dimensional approach, and that's the group of researchers I talked about earlier about concerns of open washing. And so briefly, the model openness framework, I'll just refer to it as the MOF. It actually takes those components that they came up with and groups them into three classes of increasing completeness. And they call those three classes the open model class, the open tooling class, and the open science class. And then they look at the license for the components. And if it's an OSI approved license or one that looks like it's pretty close to the OSD, if it's not software, they say it's open. And if it's not, it's closed. The dimensional approach does take a different tack. And basically what they did, they came up with 14 components and they grouped them into three areas: availability, like vectors is I think what they call them in their research paper: availability, documentation, and access. And then they evaluate each as to whether it's open based on its license, or partially open or closed. Now, they don't delineate what's the difference necessarily between, there's no red line between partial open and partially open and closed. But in both papers, they're really relying again in their judgment, in their calls, as to how close does something come to the OSD. So I actually think the table is a good way to sort of highlight what they're thinking about. So this is the completeness categories that were represented in the MOF. And so I mentioned that they came up with these three completeness categories or classifications. And the first one, the open model class, is basically what components would you need just to basically understand how the model works and its capabilities. So I have a Y for yes, you need that component, and an N for no, you don't need that component. So the open tooling class is you need everything in the open model class, but you also want to be able to test the assertions that the model producer has made. So you might need other types of testing materials and benchmarking results and things like that. So you can see there's more components here than in the open model class. And the most complete class is what they call the open science class. And that they're really just trying to inspect the model throughout its life cycle. So you have to have everything you had in the open tooling class, plus some more components. The idea is you don't need to reverse engineering to really understand everything about the model and how it works throughout its life cycle. Okay, and so now here's a sort of one table from the dimensional approach that I think it highlights, makes it easier to understand what they're doing. You can see how they have grouped their 14 components into these three vectors: availability, documentation, and access. And so if it was open, it's green. If it was closed, it's red. If it's partial, I think it maybe was supposed to be yellow. It shows up as orange on my here. And they compared in this particular figure two different AI systems, or in this case, large language models. One was the Bloom Z, and the other was Meta's Llama 2. And you can see that based on their analysis and their approach, Bloom Z is fairly open, and you can see that Llama 2 really doesn't appear to be very open. Even though Meta has actually touted it as being open source. So there's actually more closed blocks here than partially open, and there's no open blocks for Meta's Llama 2, according to this research. Okay, so let's actually think about, well, how open do systems actually need to be? So I want to go back to the problem that we're trying to solve, and that is we're just really trying to balance mitigating risks with promoting all the benefits. And so we want to make sure AI is not going to harm anyone, that we can trust it, but we really want to promote innovation around AI so that we can recognize and realize all of its benefits for everybody. So if we tell all the AI system producers, look, you've got to open up everything and show everybody everything that's under the cover, they can't keep any trade secrets. And under the OSD types of principles, they'd have to make it available to all of their competitors to use in any way they want for free. That's not really going to be a policy that's going to entice investors to invest in these businesses, and it's certainly not going to reward shareholders, which companies with shareholders are obligated to try to do. So we have to kind of recognize that not everybody needs to see everything in an AI system, and we certainly just to trust it. And certainly for trust and transparency, we don't have to provide rights so that everybody can use the AI system components any way they want for any purpose, even ones that are harmful for the business itself. So let's start with like the opposite ends of the spectrum. Let's see, can we start with a black box? And what I mean by a black box is there's no all the licensing is closed. There's no open licensing. Okay, and so if we don't give anybody access to anything under the cover, can we test it? So there's another group of researchers that came up with a certification scheme that provides a technical way, a model agnostic technical way to assess compliance with emerging AI regulations. So this research, which was led by Philip Denzel, is specifically tailored to providing conformity assessment for certain requirements in the EU AI Act. It was specific, for high risk systems, and the whole point is that it's supposed to be able to show that the system is, transparent and safe. So they validated the scheme that they came up with on a dermatology application, which they write about in their paper. Um, and one of the things that I wanted to point out is going back to, if you recall earlier, I talked about transparency and, it has different meanings, and certain meanings are more important to certain stakeholders than others. One of the first things they do is look at who are the stakeholders who care about this. And then they start to figure out, well, what technical methods do we need to use to be able to test this for that group of stakeholders? So because I am not a technical expert in model agnostic testing, I wanted to really make sure I understood what this research was telling us. So I reached out to Philip Denzel and I said, are you actually saying that you can take your certification scheme and use it to test black boxes? And I thought I would just copy his own words for you here. His answer was yes, we can do that. And my thought is, if we can do that, we should be focusing more on standardization and testing more than sort of making everything available. In other words, not having preferences for licensing. Now, he noted something that I've heard from many others, which is, oh, even if we have a test and we don't have to look under the cover at any of the components, there still may be some high risk systems where we just feel like we need to see what's there to trust it. So there still might be times where we need some type of licensing that allows at least certain people to take a look under the cover. It's sort of a belt and suspenders approach. And so this is how I came up with really what I propose in my paper, which is an access model framework, or the AMF. And it has really two components. There's a process and there's a licensing framework. If we keep in mind that the whole goal is really to actually balance, the risks and benefits in a way that doesn't really harm business model competition and innovation. We will still want to promote that. So if we start at the licenses, I just come up with two simple license frameworks. The first one is a private access license. And so maybe you have to provide some of the components, the underpinnings of these components to certain stakeholders like auditors or regulators or certain of your customers, but you could do that under NDA. There may be other situations where larger groups of stakeholders may want to see, may need to feel that they need to look under the covers to get that trust that they need for transparency, to know that it's safe. And in those cases, like think about, developers in broad groups of industries, or all university researchers doing a particular general kind of research, or governments around the world. In those cases, maybe components of the AI system need to be made available under open access license, where the components are publicly available. So I call these two license types: a private access or PA license, or an open access OA license. Now, coming back to the process, though, our object is we don't want to have to give away trade secrets if we don't need to. And we don't want to have to give away rights that are potentially would harm our business interests if we don't have to get to this balance of trust in terms of transparency. So if there is a black box test, we can use it to test. We don't have to have any licensing requirements. If there's not a test, or there is a test, but we still need to see, we still feel because it's high risk or for some other reason, we really do need to see some of the components to feel more comfortable around trusting that AI system. Then we have to actually look at, well, who are our stakeholders? Who needs to see it? And so if it's a small group of stakeholders, like auditors or regulators, we can use a PA license. If it's a really big group, we might have to use an OA license. But even so, we don't have to give away all other kinds of rights. We can say that that license is, there's a minimum bar, and it says basically, you have the right, whether it's under PA license or an OA license, to use this component or this set of components that I'm making available to you only to understand how it works and operates, makes decisions, or if there's a standard or some type of regulation, only to see if it actually comports or falls within the guardrails that are applicable to this. So it's a very clear use restriction that doesn't give people all kinds of other rights. It's just to really evaluate the trustworthiness of this AI in the right context. Now, even if you decide that you have to make some components available, it doesn't mean you have to make all of them available. So identifying the stakeholders, I kind of take that from the Denzel, the dimensional approach, I'm sorry, the certification scheme approach, and deciding what components I need to use, I'm taking that from the MOF. For different use cases and risk profiles, I may not need to actually make available every component of the AI system. So we need to look at that. Which ones need to be available? And then what license type do they need to be available under? A PA license or an OA license? Now, I want to be clear, an OA license, because it does say like the source code or the data or whatever it is of that component needs to be made publicly available. It doesn't have to grant rights for all other uses other than for testing compliance, conformance, or just understanding how it works. That's a minimum requirement. Doesn't mean that OSI approved licenses and any license that comports to the OSD principles would not be an OA license. They would. They exceed that minimum requirement. They include that minimum requirement and they exceed it. So coming to the end here, I want to say that we could actually implement this framework much more effectively if we do a couple more things. We should actually kind of, and the first two things really are focusing on what technology experts can bring to the table. So the first one is, well, as we develop these guardrails, these AI rules, it would be great to focus more on testing. Can we develop more appropriate tests so that we can test black box or partially black boxes or ones that are AI systems that are not fully open? We also need to really look at the use cases and the risk profiles along the lines that the MOF did, as to say, okay, what components, when we need access, what components would we want to have access to? Who needs to see those components? Who needs to look at them? And just overall, when does this even apply? Okay, so again, it doesn't necessarily apply to every situation, particularly if there's a black box test available. And so on the licensing side, though, I think it would be very straightforward to come up with a template language for that minimum requirement that just says, here's what you can use the software for, here's what you can do it. And all it is really is to look at it for understanding how it operates, how it makes decisions, et cetera. Or if there's an appropriate guardrail, does it stay within that guardrail? Testing for conformity assessment. For the OA licenses, there's lots of people who feel that OSI's lister that meet that minimum threshold. It would include, as I mentioned before, all of OSI's licenses, as well as many other open source licenses, like many of the ones that I talked about, the Open Rail and the ethical and the Fair Code licenses. And so, in conclusion, I just want to say thank you for listening to me. And I think if you take anything away from this, I hope that what you take away is that there really isn't a one size fits all approach to transparency, such as open source mandates, and that we should make sure that whatever we do around transparency and AI governance shouldn't drive away business model competition and the innovation that results from it. So thank you, and I'm happy to take questions. And I would appreciate any feedback. I have my contact information up there. If you have feedback or questions that don't get answered today, feel free to reach out.
Thank you very much, Michelle. So let's try to take a few questions quickly. I think overall it was very, very interesting. I noted the Be Aware license and the postcard license that you talked about. But regarding your framework, the AMF that you have proposed, so there are steps to be taken by the technical community to effectively implement the AMF that you propose, right? Can we start to implement it now, or do we need to wait for these other steps to be completed?
We can certainly implement it now. And I hope people do start to think about it now. There aren't many tests right now, so that's okay. You just go to the next step. Well, okay, who needs to have access? And whoever needs to have access, is it a small group of stakeholders like auditors or regulators? Then we could do a PA license. Is it really a large community that needs access? Well, then maybe we have to do an OA license. So I think we can do that now. I think it would be, in each case, we'll then have to, assess probably real time what components need to be made available under which license based on the facts and circumstances of, what we're trying to accomplish. But I think that's certainly doable. Um, I think it will be more efficient when we can actually come up with some of that work in advance, so we don't have to think about it as it comes up, but that's not a problem. And I think in terms of creating the templates for the PA license and the list for the OA license, we could start building that out right now. That's not a prerequisite to using the framework. It's just a helpful tool in using it.
Okay. And related to the open source licenses, so are you saying that traditional open source licenses will be harmful or should not be used for AI systems?
No, I'm not saying that they're harmful at all. I think there is this really broad spectrum of intellectual property grants, and that spectrum goes from everything is wide open in the sense that it's public domain. Okay, you can do anything you want. There's no license or anything. Just do what you want. To everything is closed off. Think about a government who has the highly secure AI algorithm system that it's using, within that government. They're not letting any parts of it out at all. So the spectrum should have everything in between those two extremes. And I think it's really important to understand that licenses like the OSI approved licenses, those types of open source licenses may really benefit like long-term research projects, they encourage public and charitable investments in those kinds of projects. But the private sector and also it's very important to research. They do a ton of research, both large and small entities, and they need investments. And in order to commercialize, it's usually a lot of their innovation is commercialization based. How can we make money off of these? But they're innovating to do that. And we want to encourage business model competition, just like product competition and price competition. We need business model competition. It's all good for innovation. And so along this spectrum, you have to give everybody the flexibility to pick the right kind of licensing structure for their AI systems that's going to make the right balance for each individual entity that's producing an AI system. So there's definitely a great the OSI approved licenses definitely contribute to the whole ecosystem, but they're just not the only game in town. And I think it's really important to give everybody the freedom to choose what's best given their situation.
Okay. Just to teasing because people will learn a lot from your research paper that is now available on the 4IP Council website and on SRN. So for those who don't know, you can easily find the document and read lots of details. But regarding OSI, I mean, the question is, do you think that OSI found the right balance in allowing AI systems to withhold their training data so long as they comply with the definitions, author requirements?
Yeah, I think that's a really important question. You know, I talked a little bit about this, but there really are very good reasons why you can't just say all the data has to be openly available and freely licensable for all purposes. So, I mean, a lot of training data is actually licensed in, and so you're under your contractual obligation, for example, not to disclose it or maybe not to use it. You can't expect developers to just breach these agreements. A lot of the data also has personally identifiable information in it, and there's privacy laws. You cannot expect them to just violate privacy laws. There's also really reasonable debates about whether or whether open systems are safer than closed systems. So on the one hand, more eyes looking at the components may make it easier to find problems like security issues and other kinds of vulnerabilities or things that people could exploit. But on the other hand, bad actors also get to look at it too, and they can see the vulnerabilities and exploit them. So from a sort of a global governance perspective, one of the things I think, because we have a broad base of people here from the EU and from the US, I think, we're seeing sort of the EU being more likely to promote open systems because they might think that's a better approach. And we're seeing like the US take a much more wait and see approach. They're being much more cautious in promoting open over closed. But coming back to your question, do the OSI get the right balance? Well, I think those things that they did are very reasonable. They're basically just saying like you can't violate laws and breach agreements. It's not always clear whether open's better than closed when it comes to the data. And we just want you to tell us what you can reasonably tell us about the data, explain what it's about, tell us where you got it, how much it's going to cost, that type of thing. That seems very reasonable. If they didn't do that and they insisted that all the data be open and freely usable for anything that anybody wanted to do with it, they would really limit open source AI systems under their definition because there wouldn't be a lot of data sets people could use. They would be very limited in the data sets. So I think that overall they definitely came up with the right balance. Although I will say lots of people disagree. It's
Yeah,
controversial.
I can imagine. But then, do you think that we need definition of open source AI then?
Now, I don't like definitions of open source software, and I don't like open source AI any better. I think it just plays into this whole open washing argument. And I really distinguish marketing. Open washing is about marketing. And if somebody wants to say my system, my software is open source, that's fine. I think there are two reasons why people actually, really wanted a definition of open source, and I'll go back to the software. It kind of applies here. People there's really these two reasons. One is this open washing reason. They don't like, they feel like people are cheating if they say something, but that's a marketing issue. Okay. The second is, as people want the ease of selecting a license and they want to make it easy to review. So let me just start with the sort of the open washing and the marketing piece. Um, you know, I just don't think that is really important. I think you have to really look at what you want the license to do and what its purpose is. And I don't think we should be constrained by strict definitions. I don't think it's really helpful to anybody. On the ease of use of a like selecting a license and reviewing a license, in the old days when open source first, became popular, is largely popular with hobbyists, not corporate entities. But now almost everybody who participates in a viable open source project is there as a corporate employee doing their job. And corporations and companies use open source all the time in their commercial products. So it's commercial software, if you will. And the thought that you need licenses to be simple for corporations to understand what they say and do doesn't make a lot of sense to me. I mean, even open source licenses on the OSI approved list, some of them are very complicated. I've like printed out like the GPLv 3, and it's like 14 pages of text. Okay, that doesn't mean it's simple to understand. So all the corporations have, better ways of assessing what licenses are. I'm going on now, but I have clients that come to me and say, I have to use a BSD license because I need to market this as open source. And I said, but you just told me you want to keep the code confidential. I do. I don't want anyone to see it while we're working on it in this group, but I want to use this open license. And I said, well, the only way you can do that is to have a separate agreement where everybody says they won't disclose it. But what's the point of then having an open source license? Oh, so we can say it's open source. So that sort of is the rationale behind all of what I just said. I see that all the time in many different ways.
That's very interesting. And I note also that some companies are making pledges. So are company pledges enforceable? And if not, are they useful?
So, I think it's questionable whether they'll be enforceable. And again, different jurisdictions' laws would tell us they're probably not contracts. Some places might look at them that way. But could somebody argue that they relied on them and were harmed? That might be the basis of a claim somewhere. That's questionable. But I think the real use of them is the court of public opinion. Okay. We all know that even if something isn't enforceable, or even if somebody wouldn't go enforce it in a court, if you make a corporate pledge and then you blatantly violate it, if people cared about that pledge, they're going to speak out, and that court of public opinion may actually have some teeth and things that corporations care about. So I think that they're not just nothing. I think that people, will expect corporations to comply with their own pledges, and if they think they're important pledges, they're going to hold them to it.
Yeah, that's a very good point. We are approaching the end of this hour. So unfortunately, we are not going to be able to take all the questions. I'm sorry about this. But that's a fascinating topic. I think that there is so much things that we can do, so much things that might change in the future as well, that will be created. Um, so maybe we'll have a follow-up webinar in the future. But this topic is definitely something that we should keep in mind. I would like to thank all the participants to this webinar for your attendance. I would like to thank you very much, Michelle, for sharing your knowledge. And I would like to raise the fact that the paper is available already on the 4IP website. And if you scan the QR code that you can see on your screen right now, you will see that you can register to the upcoming webinar that we are organizing in collaboration with the EU IPO and EFIC about the new EU design reform that will take place on April the 10th. Now, time to conclude. You will receive a form tomorrow in case you want to share future topics that you may want for IP Council to consider for the next webinars. And thank you again very much, Michelle. I would like to say have a great day, end of the day for some, and goodbye to all.